Section 143 Powers and Duties of Auditors. Every auditor can access at all times to the books of accounts, vouchers, and seek such information and the explanation from the company that he considers necessary. If he is satisfied, he is not required to disclose the fact in his report. However, on inquiry, if he finds some adverse features, it is his duty to report the same. The inquiries which are required to be made under by the auditor are with respect to loan and advances made by the company. Have to check the proper securities has been taken care while providing any loans or advances. Transactions represented by the book entries are not merely the entries, they actually existed. Sale of investments, loans and advances shown as deposit. All the rules are being complied with or not. Charging of personal expenses to the revenue account and allotment for share for cash. Subsection 2 of 143 provides for the audit report that the auditor is required to make report to the members of the company on the accounts examined by him on every financial statement which is required to be laid down in the general meeting. The audit report should take into the consideration and the provision of this Act, the accounting and auditing standards and matters which are required to be considered under this Act or the rule by thereunder. Audit report should state the best of his information and knowledge, and the said accounts and the financial statement gives true and fair view of the state of the company affair. And that shall be in the end of the financial year, and the profit and loss and the cash flow for the year, and such matter as may be prescribed. The auditor is required to provide reason where any matter is required to be included in the audit report under this clause is answered in negative or with qualifications. So summarizing the entire subsection 2 says that the auditor is required to report the matters of the company affairs with respect to the financial statement which has to be approved by the members in general meeting, and shall take into the consideration of accounting standards and auditing standards while preparing the report. He has to check the matters which is required to be included in the audit report, and where are there any negative comments or any qualification given that has to be answered by the Board of Director. The power of Comptroller and Auditor General of India in case of government companies starts from section 143 to, subsection 5 to 143 subsection 7. CAG shall appoint the auditor under subsection 5 or subsection 7, direct an auditor in which the accounts of the company are required to be audited. Auditor so appoint shall submit a copy of audit report to CAG. Among the other things, include the directions given by the CAG and the action taken on the accounts and impact on the accounts and financial statement of the company while conducting the audit. It has the right to conduct a supplementary audit of the financial statement upon and comment upon, or supplement such audit report within 60 days from the date of receipt of audit report. Apart from that, any comments given by CAG upon the supplement audit, every person entitled to the copies of audited financial statement shall also receive these comments along with the notice, section 101, and be placed before the general meeting of the company at same time. Comptroller also have the authority to cause test audit of the companies covered under 139 subsection 5 and 7, or the provision of section 19A of Comptroller Auditor General duties and powers shall apply to the test audit. Summarizing, CAG can give the direction to the government companies auditor to conduct the audit and submit the audit report to CAG, has the right to conduct a supplementary audit of the company and comment upon or supplement such audit report within 60 days, Any kind of reservation qualification given by CAG shall be circulated among the person who are entitled to attend the general meeting along with the copies of audited financial statement and also be placed before the general meeting. CAG by order caused a test audit to be conducted of the accounts of the company covered under 139 subsection 5 or subsection 7 as per his special act, and shall be considered as test audit. Section 143 subsection 3 laid down the other details which are mentioned as under, where he has sought to obtain all the information and explanation which were necessary, and if not, the details thereof, the effect of such information on the financial statement. Where he has sought and obtained, he has requested or sought any sort of information and required an explanation if necessary, which has not been provided to him. The effect of such information on the financial statement has to be given. Whether on his opinion the proper books of accounts as required by law have been kept by the company and proper return and adequate for the purpose of his audit have been received from the branches not visited by him. Whether the branch audit report prepared by a person other than the company's auditor has been sent to him. Whether the company's balance sheet, P&L, dealt with the report are in agreement with the book of accounts and return. Whether in his opinion the financial statement comply with accounting standards that is given under section 133. You can find the video regarding to this already on the channel. The observation or comments of the auditor on financial transaction or matter which have adverse effect on the functioning of company. So first, all the information obtained or which was requested, if in case it was not given, has any adverse effect on the financial statement. Proper books of accounts were maintained by the company, and along with the branch audit report for the branches which were not visited by him, it has been checked and is in conformity with the accounting standards. He has to check the balance sheet and the profit and loss account tally with the books of accounts. Going further, the director disqualifying from being appointed as a director under 164 subsection 2 has to be checked. Any qualification, reservation or adverse remark relating to the maintenance of accounts and other matters in connectivity therewithin, which complies with 128, 129. Whether the company has adequate internal financial control with reference to the financial statement in its place and operating the effectiveness of such control. Now, internal financial control has to be mandate for the companies other than one person company, small company, turnover less than 50 crore as per latest audited financial statement. Borrowing is less than, the total borrowings is less than 25 crore. Rule 11 prescribe auditor reports shall also include their views and comments on the following matter. Where the company has disclosed the impact of any of the pending litigation on the financial position and financial statement. So any sort of legal proceedings has impact on finance. Where the company has made provision as required under the law, accounting standards, or material foreseeable losses, if any, on the long-term contracts, including derivative contracts. Any sort of reserve created for future liabilities of not. Where there has been any delay in transferring amount required to be transferred under section 125 discussed on the dividend part 2 in this channel, where the company has provided requisite disclosure in financial statement as to holding as well as dealing with specified banknotes period from 8 November 2016 to the 30th December 2016, and if so, whether these were according to the books of accounts maintained by the company. So due to the demonetization, any of the transaction conducted from 8th November till 30th December has to be checked and shall be in alignment with. So this was section 143 part 1. In the next video you will see the branch audit. So it'll be 3 part to this video. First you're viewing now, second will be the branch audit, and third will be the duty of auditor to report fraud. Stay tuned, the video will be uploaded soon. Thank you.